Thank you very much. You know, I was on that committee, study committee on the Muhammad Aquifer, or a observer back in 2014, 2015. My predecessor, Representative Mitchell, asked me to sit in on those hearings. And I'm a little, I guess, concerned that one of the previous speakers, who was very, very involved, is willing to let this go, support this bill, who I believe will endanger the Muhammad Aquifer. Once you breach that aquifer, once you breach the bottom of that aquifer, and something happens, there's no way to go back. There's absolutely no way to go back and fix that. And I know, Representative Williams, you know, this is an important bill for you, and I would like to propose a couple of things that I think might bring you more bipartisan support. Some things that might or should be included or done to bring some more people along. And if you don't mind, first thing that I would say is that we ought to lower the fee. You know, you've accepted or set a fee of $31 a ton to sequester. How does that fee compare to Indiana, our neighbor?
Well, our fee is 31 cents for a ton of carbon stored, and it is broken down to a number of areas. I've heard in committee yesterday that Indiana is lower, but I would make the argument that we're dealing with much more robust, significant safeguards and protections here in Illinois. We have an extra permit requirement that other states don't have. I would argue that Illinois residents deserve the highest protection, the strongest safeguards. And if you want, I can give you a breakdown of where that fee will go. But we're obviously for the administration of the fund and the permits required and all the work that goes into keeping these safe and making sure all the I's are dotted and the T's are crossed. There's also a funds will go to the long-term trust fund, and that's what I think Representative Amons mentioned, that after 30 years, there's a trust fund established, so if a company goes out of business and is no longer able to address any concerns that may arise or any liability issues, that money goes into the fund, so that's really important to us. Additionally, some of the funds goes to the emergency preparedness to go directly to first responders in those communities, training, preparation, et cetera. We also have a component that goes to environmental justice grant funds. And this is not limited to sites where there is carbon stored. This is any EJ community for help with positive, sustainable action. So we felt that the fee was the right amount to make sure Illinoisans were protected and still fund these important components of this process.
Well, I think there's a difference of opinion, and I think that by not being competitive, and I presume that other states that look at this are going to be a lot less than Illinois. There are things in that fund that are, I think, worthwhile if we're going to do this, but I think it's also very extravagant, and I would suggest that if you pared that fee down, it would be, I think, more palatable. I think another suggestion that I would have, had we been able to participate in this negotiations. Well, we talk about the eminent domain, the part of this that goes towards eminent domain, which you know is a big sticking point for many, many of us. And one of the concerns is the use of eminent domain and how that goes forward. But if I were to suggest a change, when you talk about the 75% threshold to have acceptance, and then you go to the other 25% that don't, we have that they're forced to go through an arbitration process. In that arbitration process is the upfront payment, the bonus payments that have been predominantly used in other environmental issues. Is that considered in the, I guess, the eminent domain process?
Before I answer that specific question, just to kind of clarify, the eminent domain laws that exist right now and apply to pipelines, no matter what kind of pipelines they are, have been unchanged. So for pipelines, eminent domain is indeed the process. Highways, everything for public use, that's separate.
I understand that.
Yeah.
But what we have seen in the past is that a developer will front load. In other words, they will offer an incentive to a landowner to accept their project, and then the rest of the people that haven't gone along are subject to a hearing, to an eminent domain process, where we try to reach an agreement. But the eminent domain process, to get to an equitable payment, to keep somebody from holding out and trying to game the system, but it doesn't include that upfront payment in consideration of what that average or mean payment is.
Well, let me clarify that a little bit. First of all, we're not talking about eminent domain if we're not talking about the pipelines. What we're talking about here that you're referring to is the pore space that lies deep underground where the carbon is stored, as you know, and does not deal with surface rights at all. So I have looked at the actual language of the bill after hearing from you guys in committee. And how it works is that if there's 75% of the owners of 75% of the land, the associated owners agree, then the process can move forward. It's called unitization. It's like an easement. It's not eminent domain. The ownership is retained of that pore space from the landowner. And they call them non-consenting landowners, then utilize a process through DNR where they will, as you mentioned, have a hearing, go in front of an ALJ or an administrative hearing officer, and the determination will be made based on a number of factors. So while the average is not calculated using an upfront payment, which is an incentive to get you to sign up early, the just compensation includes fair market value considerations. Changes to your land value, if any. It's a floor, too. The average is just a floor. So the average is calculated based on the past year of payments, and then the hearing officer can hear any evidence you choose to provide. So
I understand that.
If in the hypothetical situation, someone decided to abuse the process, front load all the payments and don't make any ongoing payments, the non-conforming landowners or non-consenting landowners could go to the administrator and say, this is being front-loaded, we want just compensation throughout the process, and it would be considered. There is discretion. So I don't see that concern as really being valid.
I understand the discretion, but we're talking about what's in a bill this could become law. And I think it would be better for this bill if that discretion was removed and the upload payment was absolute. That would be absolutely considered in those negotiations. But let's talk about another.
Sure.
The Muhammad Aquifer, we've said it and done it and said it again, and I think it would make this bill much better had we agreed to protect the Muhammad Aquifer. I think that is a huge sticking point. It should be a huge sticking point with every member in a consideration of every member in this body. And I understand it wasn't because there's some permits that are out there or people are applying for permits, and the labor unions felt that it would inhibit some work that they might get. But I firmly believe, and we've heard it from others, that once you permeate the aquifer, once you go through it and something happens, there's no going back. One last point, and that's the moratorium. You know, we have actually, and you mentioned it, a company that's proposing to sequester out of Gibson City. And it's a short pipeline. It's a short pipeline. And I would suggest, rather than interfering with that process that's ongoing, that perhaps the moratorium should only affect pipelines over, say, 10 miles. You know, this is not about people bringing pipelines in from other states or shipping, making a pipeline run the length from Waukegan to central Illinois. I think it would be much better if you would exempt pipelines, short pipelines, like the one ADM has, like the one that they're proposing in Gibson City. Don't interfere with that already permitting process. They're already working. They want to sequester the carbon. They want to do this project, but we're putting a moratorium on them. we're putting restraints on them that I think are going to interfere with doing what you want. I mean, we're doing what your caucus wants, and you want to pull CO2 out of that fermentation process, out of the ethanol plant. I think it would be a good idea to let that process play out. If they can get the farmers to agree to sequester, they can run that pipeline and get an ICC permit and get a Class 6 well permit. I think this interferes with that process. And it may give us another commercial application of this sequestration that would be very, very helpful as we go down the road as an example of how things should be done, could be done, and maybe it would make this process more palatable. So those would be my suggestions. Perhaps had we been allowed to be involved in negotiations, we could have dealt with this sooner. But without these safeguards, without these things, unfortunately, I can't support this bill at this time, but I certainly appreciate your hard work.
Thank you.